All right, and then Rules of Civil Procedure 45. You got to know Rule of Civil Procedure 45. I give you some references there to learn more. So you've got 4 types of subpoenas. What do you do with the subpoena? You draft. And I give you a nice summary there, but you need to know, especially the subpoena duces tecum with the production in lieu of appearance, send that to the business separately. Belt and suspenders. Some lawyers will wait and say, well, we may get all that stuff through interrogatories and requests for production of documents. Anytime you hear a lawyer say, let's wait and see, they're a loser.
Miles?
Yes.
Is there a point in a case where
Yes.
it's not, let me finish, where it's not appropriate from the attorney standpoint to try to get subpoenas yet? I mean,
No.
so they can do it anytime they want to.
Yes. And that's, I knew. Yes, that's, you were asking that question. I'm like, yes. They wait too long. Oh, we're going to get that with this, we're going to get that with that. No, you're not. Do both. Require the discovery be answered under oath, the interrogatories, under oath, and issue a separate subpoena to the business. But and what we're going to talk about next is why the lawyer screwed that up, because subpoenas are hard. Certain parts of subpoenas are hard. And they changed the rules about 10 years ago to make it even harder. And we'll talk about that in just a second. So you've got to know what to ask for. A lot of the lawyers don't have the documents they need from the business listed. And they're embarrassed of that. So give it to them. Give it to them. All right, how do you serve it? So once you figure out what you're going to subpoena, and again, my book has them all. And if you're buddies with another forensic accountant, they'll probably share a list with you. But they're in publications of NACVA, AICPA. Get those publications. Hold them up. Say, here's where I got it from. All right. Know the name of the exact legal entity. How do you do that? Go look it up, Secretary of State. You're probably going to do that anyway on the business valuation. So go look it up yourself. Spoon feed the lawyer. All right? Plus, you're going to do a general background on the business anyway. So help the lawyer with who to serve. Because on the Secretary of State website, they're going to give you the registered agent for service of process. And if it's CT Corp out of Knoxville, you just certified mail them. Well, half the lawyers you work with don't know that. I'm telling you. All right, calendar the date due. The next step is not written down anywhere, but confirm they received it. Be nice, call somebody on there. We have our paralegals, call the legal department or wherever. Hey, did you get our subpoena? Is there anything we can do to help you out with it? They always say no, but we know we got it. And the paralegal says something nice to them. Here's my email address. If I can help you out with something, let me know. Okay? You got to follow up if it's not given to you on the time due. And then you got to do, if you don't get it, you need to send them an email that says we're gonna do a motion to compel subpoena compliance. In the materials, in the PDFs section for my materials, I've got a motion to enforce a subpoena compliance. I think there's an affidavit attached to it, as well as a sample subpoena, all in there, so you can see what it looks like. And you're going to have to go file motions to compel subpoena enforcement. That's what A-list lawyers do. They don't issue subpoenas. They don't wait to issue them. You don't wait. You issue them. Because if you got to go through the motion to compel enforcement, that may be a multi-month process just to get into the courtroom. All right? And it used to be, the rules were a little bit different, and the impetus was on the recipient. Now it's on the issuer. They switched that. I don't like that. But and then you can ask for legal fees, and then you can suggest to the lawyers that you're working with to make the business a third-party defendant to the action. If it's a divorce, obviously, you may want to do that for no other reason than to get sanctions. The judge is more likely to issue sanctions if the third-party business is made a separate defendant. Now, also with the defendant, third-party defendant's status, it generally gets them a little closer to doing what they need to be doing. So if I have my druthers, I always recommend we issue a subpoena to the business when we make them a third-party defendant. And there's plenty of cases out there in Tennessee where there are third-party defendants to divorces. And nobody's ever, to my knowledge, and I should know this if it had in Tennessee law, objected, and the Court of Appeals says, yeah, shouldn't be third-party defendants. That's never happened.